morning. Yes, let's start.
The daily was this under the heading orders with defect, serial number 1, item number 9 of 22. Mr. Rahul Kumar Gupta, Mr. Akshay Verma was of
In this, Your Lordship, I have been informed that we have removed all the defects, but I don't know why it has again. I had taken time for filing the certified copy of the impugned order, which we had already filed about a week back. It is also showing in the.
What is this? Under the heading for orders?
No, it is for defect.
What is this order?
Initially, certified copy of the impugned order had not been filed, which we have already filed.
Let's go order. Let's place this. You have removed the defect.
According to me, I had not filed initially the certified copy of the impugned order, which we had filed, and it is showing in the case status of 16/2/2022. We have filed, it is showing in the case status. So according to my clerk, no more defect is surviving, but I'm not aware if any fresh.
There's a further stamp report. Further stamp report.
Then I may be allowed some time. I'll see, verify what is there.
3 weeks.
Yes.
3 weeks to remove the defect.
Under the heading for orders, serial number 2, item number 137 of 16, Mr. Nagmani Tiwari.
Milords, in this case, Milords, so go out the list, Milords, because it was filed in the year 2016 in the month of March, Milord.
Okay. Let this case go out of my list to be listed before an appropriate bench.
Serial number 3, MA number 38 of 16, Mr. Manish Kumar Bhadla.
My lords, in this case, my lords, also paper publication was directed, my lords, and by order dated 17th February 2020. We submitted the draft on, my lords, 26th February 2020, but it could not be collected from the office, so still it has not been done. Right? So sometime may kindly.
Counsel for the appellant will furnish fresh draft of notice to be published. In the new local newspaper as directed earlier. No. Office to proceed thereafter.
Right.
Serial number 4, MA number 440 of 16, Mr. Dilip Kumar Karmakar.
Yes,
Mr. In this case, I am appearing on behalf of the appellant filer. Well, in this case, earlier notice was issued. Notice was issued on 3/12/2019, and thereafter on 22nd/1/2020, it was listed before this honorable court as there was no service report. 2 weeks time was allowed. Thereafter, this case today listed, my lord, only. And as per list, nobody appears. Well, what is the service report? I could not see as because we are in DC.
The address is not specific. It's a generic address which you has given, and it is impossible to serve notice with this in this address.
Others respondent is also there, and that is as because there was no stress. That is why general public.
No, public.
Party has
the address which you have given to respondent number 226 is absolutely it's vague. If you write that Dilip Kumar Karmakar Hinu Ranchi, how can a person find him?
No, my lord, after pointing out the defects in regard to the address, it has already been corrected, my lord. Thereafter, notice was issued, my lord.
No, it has not been corrected. fresh notice to respondent number 226 in present, correct and specific address. Requisites 4 weeks. 4 weeks.
Yes, my oblige.
Ordinary process.
4 weeks, my lord.
4 weeks.
Serial number 5, MN number 458 of 16, Mr. Sudhir Kumar Sharma, Mr. Suraj Kumar Mati, for the village.
Yes, Mr. Sharma. No one appears.
I am appearing on behalf of the respondent, my lord, MA number 450, 2006.
No one appears on behalf of the petitioner. This case is adjourned to be listed. The physical hearing.
My lord, matter is urgent, my lord. Therefore, my lord, a date,
What is
if
urgency?
possible.
What is the urgency?
What happened, by my lord, by the impugn judgment, my lord, learned court below has granted succession with respect to 1/3 of the property, my lord. Though I have paid for 100%, but it has been granted only to the extent of 1/3. And that amount I want to avail, my lord.
Who is stopping you?
Because of pendency of this, my lord.
No, no. You file an application, you file a proof that because of this, only because of mere pendency, you are not being allowed to withdraw the said amount, then I will take action.
My lord.
There's no stay, I think. There is no stay.
Yes,
is there
sir.
any stay of proceeding? Then
In the next week, my lord.
no,
1 week.
not necessarily. There is no stay. You are the respondent and go and get the fruit of the order. Who is stopping you? No one is stopping you. Is there any stay of proceeding?
That I have to verify from the
You
High
don't
Court.
know. You also don't know. Then physical hearing.
It is under the heading for orders, my lord.
It will be under the heading for orders in the physical hearing date.
Obviously.
Yes, next.
Serial number 6, MN number 475 of 16, Mr. A.K. Sahni.
Lordship, this is an appeal against the order refusing to grant injunction. And my lord, valuation of the appeal is less than rupees 25 lakhs. So my lord, it may be transferred to the learned district judge Kodarma.
The initial order was passed by the sub-judge.
Lordship. Therefore,
Order
my lord, appeal would be maintainable before the district judge, Lordship.
Order 47, Rule 1R.
43 1R, Lordship.
43. Order 43, Rule 1R.
Obliged, Lordship. Obliged.
Then order 43, it will be before the district judge. Nikita?
Lordship.
Evaluation
Lordship.
of this suit is within the pecuniary jurisdiction of the principal district judge. Full stop. Next para. This appeal, this miscellaneous appeal has been filed against an order passed by the sub-judge first, Kodarma, entitled suit number 49 of 2010 by exercising jurisdiction under order 39, rule 1 and 2 of the CPC. Full stop. Any order passed is appealable under order 43, rule 1R of the CPC. Full stop. Since the pecuniary jurisdiction, since the appellate jurisdiction is with the principal district judge Kodarma, this appeal be transferred immediately to the principal district judge Kodarma.
Lordship.
Serial number 7, MA number 484 of 16.
Lordship, notices were issued on 25/1/17, and on the same day notices has been filed, but I am not aware of service report, Lordship.
Fresh notice and correct and present address to respondent number 123, 6 weeks, ordinary process.
Obliged, Lordship.
Serial number 8 with serial number 9, MA number 456 of 16 with MA number 593 of 16. Mr. Ashutosh Anand for appealing first case, Mr. Amit Kumar Lal for appealing in second case.
In item number 9, my lord,
Yes.
I am the appellant, my lord. I have filed one IE application, my lord, that appellant number 2 has died, leaving behind all the remaining appellants. They are all on record, my lord. So for deletion of this number 2, my appellant number 2.
Returned as no residence. No one could tell about his name and address. Again, no one appears. This order will be in MA number 546 of 16. Fresh notice to respondent number 6 and 7 and correct present address, ordinary process, requisites 4 weeks. Next case, take down MA 593 of 2016, IA number 6938 of 2021. Full stop. The appellant has brought to the notice of this court, by preferring this interlocutory application, that the appellant number 2, namely Abhimanyu Rai, has expired.
My lord.
Has expired. Full stop. The death certificate has also been brought on record. Full stop. Next para. It is submitted that the legal heirs of Abhimanyu Rai is already on record. So the name of Abhimanyu Rai may be deleted from the cause title. And there is no necessity of substituting the deceased appellant number 2. Full stop. Considering his submission, the name of appellant number 2 is deleted. Full stop. Necessary corrections to be carried out in writing within 15 days. By your disposed of.
Serial number 10 with serial number 11, MA number 5 of 16 with MA number 591 of 16. Mr. Manish Kumar for appealing first case, Mr. Amit Kumar Lal for appealing in second case.
My lords, notices were issued in my case on 26/3/14 by order dated 14/9/2019 on 1 to 12, my lords.
Issue fresh notice to respondent number 4, and 10. Ordinary process. Correct and present address, requisites 4 weeks.
Obliged. In this case, my lord, my humble submission is that Bajaj Alliance Insurance Company, arising out of the same impugned award, has also filed one appeal, my lord. That is MA 263 of 17.
List these cases along with let MA number
263 of 17.
17 be also listed along with these cases.
My lord.
Serial number 12, MA number 557 of 16 with serial number 13, MA number 594 of 16. Mr. Arvind Kumar Lal for applying in first case, Mr. Manoj Kumar Saab for applying in second case.
My lord, with respect of serial number 13, my lord, sole appellant died, my lord.
So you have filed any application?
No, my lord, I will file, my lord.
On the request of Mr. Manoj Kumar Shah, appearing in MA number 594 of 2016, this case is adjourned for 6 weeks.
And in item number 12, my lord, as I got same accident, the same appellant of item number 13, that is respondent 6 in my case, is died. Therefore, I am also to file.
Both on the request of both Mr. Arvind Kumar Lal and Mr. Manoj Kumar Shah.
And Your Lordship, may I say one thing? In the second appeal, Your Lordship, Reliance General Insurance Company is also a party. However, it has not been served upon us and we haven't filed our wakalatnama.
You serve both the parties, please serve.
In the first matter, it has been served, Your Lordship, in the serial number 13.
Mr. Manoj Shah, serve a copy.
Obliged, ma'am.
In the office of Amit Das.
Lordship. Obliged, Your Lordship.
Yes, next.
Serial number 14, MA number 578 of 16, Mr. Ashutosh Anand. Requisites not filed for order.
My lords, in this case, I was earlier notices were issued, my lords, against all the parties. My lord, the owner is in appeal, and my lord, in this case, lower court record.
Order.
I'm sorry, my lord.
3 weeks time to comply the earlier order.
My lord, I'll just check the orders, my lord.
You have not filed requisites.
But the requisites, perhaps. My lord, I'll check it, my lords. I'll check it, my lords. I'll check it.
Yes.
Serial number 15, MA number 607 of 16, Mr. Arun Kumar.
No one appears. Physical court date.
I am on behalf of the respondent number 11 to 14, Your Lordship. The client is not contacted with me, Your Lordship.
Yes.
I am on behalf of the respondent number 11 to 14, Your Lordship.
So the appellant is not here, you wait.
Oh, okay.
Let me steps first. Yes.
Serial number 16, MA number 61016, Mr. BC Gold.
My lord, earlier notices were issued. Thereafter, regarding the office note.
My lord, in this case, I am appearing on behalf of the respondent number 4, the owner of the vehicle.
Who is for the claimant? Mr. Sudhir Sahai.
I am appearing on behalf of the owner of the vehicle, my lord. Respondent number 4.
Sudhir Sahai is with you, your associate.
Yeah, I am associated with Advocate Sudhir Sahai.
Who are the others? Notice? Not. Notices have validly been served. First up, respondent number 4 has already appeared. IA number 2335 of 2017. First up, this application has been filed to condone the delay of 8 days.
G.
Which occurred in filing this appeal. Full stop, next para. After going through the petition, especially paragraph 3, 4, and 5, I find that sufficient ground has been shown to condone the delay of 8 days. Delay condoned. Is this case under the IA allowed? Is this case under the hearing for admission?
Serial number 17, MA number 634 of 16, Mr. PC Sinha for the appellant.
Yes, Lordship, I am for the appellant. In this case, notices were issued to respondent number 123, which was filed on 31st/7/2018. There is no insurance company lordship liability upon the owner. Although lordship, owner has also filed one appeal, but that has been dismissed for default. I am not aware, lordship, whether notices were served to them or not.
Notice upon respondent number 1 has been received by the son, by the son of respondent number 1. Notice upon respondent number 2 has been received by the nephew, and notice upon respondent number 3 has been received by the father of respondent number 3. Next, the notices are thus validly served. Good stuff. Next one, there is 104 IE number 4034 of 2018. There is 114 days delay in filing this appeal. This application has been filed under Section 5 of the Limitation Act, praying therein to condone the delay of 114 days. First up, I've gone through the petition filed under Section 5. Considering the statement made in paragraph 5, 6, 7, 8, I am inclined, I find that sufficient ground has been shown to condone the delay. Delay condoned, IA allowed, is this case under the heading for admission.
Serial number 18, and number 247 of 18, Mr. P.C. Sinha.
Yes, lordship, in this case, Mr. Manish Kumar has given some proposal, lordship. It was to be rectified, verified by the company, lordship.
Yes, Mr. Manish Kumar, where are you? Where is Mr. Manish Kumar? Mr. Manish Kumar? Has he given you any proposal?
I'm sorry, my lords.
Yes.
I'm sorry, my lords, I was in another court, my lords.
Yes. What about the proposal?
Whereas in this case, I have received instruction. The company is saying that matter may be referred to Lok Adalat. They will try to negotiate with the claimant, my lords.
No. Let's see. Let us see.
इसमें जो वो प्रपोजल है 15,12,000 प्लस 50,000.
नहीं वो प्रपोजल कुछ नहीं है, वो कैलकुलेट किए गए थे एज पर डायरेक्शन.
कैलकुलेट किया गया था वो जो
कैलकुलेट किए हैं, कंपनी प्रपोजल नहीं दिया.
इसमें 5,000 इनकम के आधार पर वो जो जोड़ा गया था प्लस 40% फ्यूचर प्रोस्पेक्ट और मल्टीप्लायर 18 था.
I had calculated any amounts?
माय लॉर्ड्स, कैलकुलेशन हमको डायरेक्शन दिया गया था कि 5,000 के आधार पर कैलकुलेट करके लिस्ट आपको देने के लिए और इनको देने के लिए. लिस्ट हम कंपनी को भी दिए हैं. कंपनी का कहना है कि चूंकि देयर इज नो एविडेंस ऑफ एम्प्लॉयमेंट, एक लाइसेंस इन्होंने दिया है, इसलिए कोर्ट ने इनको एक भी पैसा नहीं दिया था टुवर्ड्स लॉस ऑफ फ्यूचर इनकम. तो कंपनी का कहना है कि अगर लोक अदालत में जाएगा तो देन देयर विल बी चांसेस ऑफ कंपनी रेडी फॉर सेटलमेंट, माय लॉर्ड्स. The only issue is that it will be thrashed at the before the claim with the claimant, my lord.
Injury.
Yes, वो दाहिना पैर इनका कट गया है घुटना के नीचे.
100% हुआ था वो जो
100%. He is a driver. Professional license है. तो कितना what was the amount you calculated as per my direction? Unmute yourself, Manish. Mr. Manish, unmute. Mr. Manish, unmute yourself.
My lord, 15,12,000 रुपया इनको लॉस ऑफ हुआ था. इसको पास ओवर किया जाए फॉर फ्यू केसेस, माय लॉर्ड. हमको लगा था कि इट विल बी रेफर टू लोक अदालत फॉर फ्यू केसेस. ऑर्डर्स का लास्ट केस के बाद कॉल कीजिए.
No. As per you, it was calculation to 15 lakh. What is your instruction, Mr. Sinha?
हमको जो अमाउंट दिया गया था हुजूर, हम उसमें एग्री थे. हमने भी इंस्ट्रक्शन लिया था इस प्रपोजल के आधार पर और इसमें हुजूर लास्ट डेट में बहस भी हुआ था मेडिकल वगैरह के लिए, लेकिन ये जो अमाउंट है हुजूर हम इस पर तैयार हैं हुजूर.
There is a chance of settlement. We'll stop considering the aforesaid fact. Let this matter be referred to the Lok Adalat to be held in the premises of the Jharkhand High Court and so and so. 12th.
Obliged.
I'll try to resolve this.
Yes, yes.
Serial number 19, MA number 26 of 20, Mr. Alok Lal for the appellant.
But in this case, we have filed an application for the stay of execution proceeding. Or in this case, our defense is that the bus was not insured. The liability has been fixed upon the bus. As per the usual order, my lord, we'll comply. But the thing is that the amount may not be disbursed because there is no policy of the bus. And it's a case of injury. 8,62,000 has been awarded.
The court has held that there is a policy.
Yes. And the right of recovery has been given. My contention would be that when there is no policy, how can we ask to pay recover?
No policy. So where is the finding? Where is the finding that there is a policy?
That kindly come to
which insurance company?
Which is Future Generally. Future Generally.
So there was a policy. What is X2?
But we are we have disputed the policy. That is in paragraph 7 of the award. But despite of that, in paragraph 4 we have taken a stand. But in paragraph 7, the tribunal has come to a finding that there is a policy, therefore you are liable to pay. Exhibit X by 7.
So a policy was produced.
So we have denied it.
Denied it means? Is
We
it
have
forged?
We have stated in our written statement, which will be apparent from paragraph 4.
Is what is the stand in paragraph 4?
My lord, in this paragraph 4, the claim petition has to be proved in a strict proof. Thereon, further period, the policy number not entitled to get any relief and no policy has been issued against vehicle number such and such. It is further pleaded that OP denied the income of the insured, which is 46 lakhs.
But you said that no policy was issued in respect of vehicle number so and so.
Bus.
Now they have brought a document which was marked X for identification, which is a policy certificate bearing number so and so, valid from so and so. Now they have primarily discharged their owners. Now the owner shifted upon you. Now what have you brought on record in support of your contention? Or in rebuttal?
That would be apparent from the LCR, lower court record, which I do not have. That I do not have. But my contention would be the right of recovery has been given, but whether the right of recovery would be effective in case when there is no policy.
Mr. Lal, again. First, let us decide whether there is no policy.
Yes.
And how do you discharge your liability? The owners, rather.
Well, that would be apparent from the lower court record, which fortunately I do not have. At
the by limitation also.
291 days.
Notice has to go first.
Yes, notice has to go. And in the meanwhile, field deposit and some stay may be given, because they are.
What is the stage?
Stage, they are pressing hard because every day we are receiving the threat from the court that you deposit, otherwise we will proceed. They file an application for attachment of our property. The petition is also enclosed herein.
So, what is the normal lending rate now by the RBI?
Normal is, as usual, some amount is being deposited.
No, I'm asking, what is the normal lending rate? If
Normal
you want,
lending rate is as per the RBI. It is in the fixed deposits. It is hardly more than 5%.
no, I'm asking you, what is the normal lending rate? If today I want to take a loan for a business purpose, how much interest I have to pay? This is the normal lending rate. It is not for
7 to 8% perhaps, as I could understand.
how much?
I don't know, I have no idea about it. Because in housing loans, they are giving 7.5% to 8.5%.
Business purpose. That is the maximum which is there as per their schedule. It is most probably 11% or 12%.
But I have no idea about it.
I will not stay. I will stay the proceeding rather. I will stay the execution case. The money will be with you. But from today onwards, this entire decretal amount will carry an interest at the rate of 12% per annum.
But that will be too harsh. But in that case, I'm coming to that. I'm coming to that.
Mr. Lal, yes, Lal, tell me one thing. You received premiums?
We have received in this case,
not in this first. Listen.
Yes.
You receive premium in relation to all the vehicles which you insure?
Yes.
This is a huge money.
Yes.
How do you earn from this money? You definitely lend. You are a financial institution, you definitely lend.
But some amount is given to the government in the government coffer. Certain amount is given to the government coffer.
Yes.
And as per the actuarial science, only some of the amount is released to the insurance company for maintaining their offices and for running the business. It is a very, I'm not aware about it. I'll inquire from my officers.
And Mr. Lal?
Yes, Your Lordship.
Some of your amount is also insured. You keep it as an insurance with the foreign companies also.
Yes, I'm coming to that. That is a policy of reinsurance. But in this case, Mr. Lal is yes, Mr. Lal, you say, I'll argue.
Mr. Lal has said nothing, Mr. Alok Lal, please.
This is the international reinsurance Mr. Lal will refer. But in that case,
Mr. Lal, don't take name of Mr. Arvind Lal. He has not uttered a single word. He's just
the simple thing is, my lord, the simple thing is that whenever we buy a policy for a motor car, in policy, my lord will find there is a compulsory excess word used. So that shows the solvency level of the person buying that policy, meaning thereby, if anything happens to the car and if the repair is made or loss is sustained, in that case, the amount of that policy excess, whatever the amount we are incurring in repair or making the good loss, that amount would be deducted, meaning thereby, if I get a repair car through the insurance company by another policy, and the repair has 10,000, then in that case, the amount which is mentioned in the policy excess, that will be deducted. That only over and above that amount will be paid. So it is the same thing. It is the same thing with the reinsurance. The international reinsurance, they have fixed and allocated a fund against each insurance policies. Now, it is if over and above the amount exceeds, only then the reinsurance will come into picture and they will pay. Otherwise, if it is within that amount, they will not pay anything.
Only one simple question. What are your source of income?
My source of income is the policy and the income and the investment which I make.
What is the return of your investments?
Well, that I don't have the balance sheet. I cannot.
Ask your officer what is the return of your investments. It is more than 10%, it should be. If your return on investment is more than 10%, then from henceforth, I will stay all the execution cases filed against the insurance company with a rider that from the date of stay till payment, the amount will carry an interest at the rate of 10 or 12% per annum.
Well, may I submit one thing then? I'll be relying upon one judgment of the Honorable Supreme Court. Yes, I'll be relying upon that. If my lord is going to pass that order, then I may submit one thing. There is a judgment of Supreme Court, Manoj Kumar Gupta versus Haseen Bano. In that case, it has been submitted by the head observed by the Supreme Court that the amount, the full amount should not be deposited in the case of stay. That is Manoj Gupta versus Haseen Bano. The full amount cannot be directed to be deposited.
Where?
In execution proceeding in the MSCT cases. I can cite that judgment. I'm having
understand. I'm not able to understand.
For deposit of amount in the case of stay,
I'm not asking you to deposit any amount.
Yes.
No amount will be deposited. You will not be allowed to deposit any amount. It will be simpliciter stay of the execution proceeding till this miscellaneous appeal is decided. But since you have the amount you have withheld and you have used for your purpose, it will be deemed that you have used it for commercial purpose of a money of someone, you have to pay at the commercial rate interest.
But so far the interest rate is concerned and CPC.
Tomorrow, if you go to the bank, Mr. Lal, if you go to the bank and you ask for a loan for your business purpose, for commercial purpose, how much interest the bank will charge?
I'll have to ascertain this thing. I am not aware of it. But the thing is that I'm not aware of this. I have never exercised my effort to inquire about this thing because I had no occasion to buy anything. I had no occasion to go to the bank for lending anything. I could not have I don't have any of this thing. I deposit the amount and I consume the amount, whatever the fees are given to me.
Sufficient money so that you don't go to the bank.
No, it is not that. It is not that. It is not that. It is not that. Whatever the fee they pay, I take out for the purpose which I might use and nothing else.
The amount of this person which is legally entitled to, be it 1 rupee, be it 10 lakh rupees, keep it with you, use it for this period, pay interest on that at the commercial rates.
Commercial rate interest will not apply as because in that connection I would rely upon I would submit on because of this thing, what you call the section 171. It would be simple interest and the rate has not been prescribed. I'm coming to that, Your Worship. Please bear with me for a moment.
Yes.
Please bear with me for a moment.
Yes, you tell.
Yes, the amount which is to be carried out, as the Supreme Court has number of cases has held, the deposits on which the scheduled bank grants, that is the Dharampal case at 6.5%. Now there is no uniformity. It is the prerogative of the honorable judge to pass the interest. What would be the rate of interest? But it cannot be commercial rate interest and it cannot be higher than the rate of the amount which has been deposited in the fixed deposit banks. So now, because that is always fluctuating. Now, if we go through the WC Act, to the WC Act, the rate is fixed, but it is not fixed in the Motor Vehicle Act. So therefore, we will have to take a recourse either under Interest Act or under the CPC.
What is the Interest Act and what is the CPC? Section 34 of the CPC.
34 of the CPC.
And the interest.
Santoshi.
Show me. Tell me. Unmute yourself. Interest Act.
Yes. Where and insofar the decree is for the payment of money, the court may, in decree, order the interest at such rate as the court deems reasonable to be paid on the principal adjudged from the date of suit to the date of decree, in addition to any interest adjudged on such principal sum and for a period prior to the institution of suit, with further interest as such rate not exceeding 6% per annum.
This is further
Yes,
interest. This is
6%
further.
per annum as the court deems fit and
Further.
reasonable on such principle from the date of with further interest at rates not exceeding 6%. The
This is
court
further
deems reasonable
interest.
and as such the principal sum from the date the decree or the date of payment of such decree provided at where the liability in relation to sum adjudged has been arisen out of commercial transaction. The rate of such further interest may exceed 6% per annum, but shall not exceed the contractual rate of interest where there is no contractual rate. The rate of interest which money are lent or advanced by the nationalized bank in relation to the commercial transaction. So it is not a commercial transaction. It is not a commercial transaction. It is not a commercial transaction.
Mr. Lal, let me
Yes, Lord.
tell you one thing.
Yes.
You keep a money of a particular person,
Yes.
10 lakhs, and from that you earn 10%, and you say that I will give only 6%. That means 4% is your income from the money of that person. Why should I allow you to keep that 4%?
But I have to ascertain what is the rate of interest, what they are lending their what they are getting. That I cannot say.
Yes.
I cannot say because without getting any instruction from the officers. Because
Yes.
in every cases there are different rates.
Yes, you seek instructions. You seek instruction.
Okay, I'll see.
Seek instruction.
And the interest act is also there. So
If you
whatever.
say, and if you say that yes, I only take 3% interest. If you say that I only take 3% interest, 4% interest, then I will record that and I will tell all the lawyers to go and take loan from you.
Well, I cannot say. I have no idea about it. So the thing which I have no idea, I cannot submit, my lord. I cannot say.
You take some idea. You take some idea and pass on this idea to me. The information.
I cannot submit anything which is not within my knowledge. I am not aware of it.
After 2 weeks.
After 3 weeks, करिए हम पता कर लेते हैं इसमें.
After 3 weeks, let's discuss after 3 weeks.
With permission, my lord, may I add something?
Permission not granted. Permission not granted. Permission not granted.
My lord.
Yes. Next. Notice. In the meantime, notice, Mr. Lal.
All right, by ordinary process.
Yes, ordinary process to all the respondents requisites 3 weeks.
All right.
Let's discuss thereafter. Yes.
Under the heading for admission, serial number 20, serial number 21, MN number 282 of 16, with MN number 297 of 16, Mr. Arvind Kumar Lal for appealing both the cases, Mr. Sharan Siddiq, Mr. Prashant Kumar Srivastava for responding in first case, Mr. Prashant Kumar Srivastava, Mr. Pratish Kumar responding in second case.
Yes, Mr. Lal, now. Mr. Arvind Lal, unmute yourself.
I'm sorry, my lord.
Yes.
Both appeals for further enhancement of the awarded amount of compensation, my lord. In first case, that is Gunja Kumari, MA 282-16. Before I start my argument, my lord, I will submit one thing, that there was originally 3 claimants. One, the mother of the deceased died on 29/9/13, and in the court below, her name has been deleted. And number 2, Vinod Kumar Singh, the father of the deceased, also died. Now only the married sister of the deceased is left behind as a claimant, my lord. So originally there were 3 claimants. Now the case is that deceased was 20 years old, my lord. He was earning from tuition 10,000 rupees per month, but the learned court below has assessed 4,000 rupees, my lord, and no future prospect has been allowed. And meager amount of estate, that is funeral 5,000, loss of estate 10,000 has been given, my lord. So my case is lying in very narrow compass regarding quantum of compensation.
Yes, taken 4,000.
My lord.
Deducted 1/3.
My lord.
Deducted 1/3.
My lord. Multiplier 17 allowed. He was 20 years old, my lord. Ought to be 18.
He's a bachelor.
Yes, my lord.
He was a bachelor.
My lord.
So deduction would be one third. There is no problem.
My lord, deduction should be, my lords, in my respectful submission, my lords, it should be half. As far as the income is concerned, as far as the income,
Why half?
lords, in view of Sarla Verma, para 30 and 31.
In view of chronicity, which says if there are other younger siblings of the dependent, as a dependent, then one third.
For unmarried, my lords, it is settled law that even Pranay Sethi has approved the ratio of Sarla Verma that for unmarried persons, since they have a tendency to spend more, so accordingly half only has been taken in Sarla Verma, followed by Pranay Sethi. And my lord, as far as the income is concerned,
Pranay Sethi judgment dekhe to. There is some reference about the siblings in Pranay Sethi also. Yes, Mr. Lal. Find out that paragraph. Multiplier would have been 18 in this case.
yes, multiplier would be 18. But as regards the income which has been claimed, my lords, my respectful submission is, if your lordship sees the evidence of CW3, because they say that they were doing tuitions. Now there were two persons. One of the deceased is in the appeal number 1, Suraj Singh, and the second deceased was Rajesh Kumar Jha in the second case, my lords. Now, as per the direct evidence of CW3, who was a student in that tutorial class, he says there were 50 students and per student there was 100 rupees which were being paid. So 50 students multiplied by 100 is 5,000. So as per their own case, it was only 2.5 thousand, 2,500. But the learned,
how many batches?
Lords, there was no evidence to that effect. The total students was 50 and 100 rupees per student.
There is no denial that he was a teacher.
No, he was this person was a student in he was doing BA honors, and it was claimed by them that they had a tuition. He was doing some tuition classes also side by side. He was taking he was a tutor. He was taking tuition classes also. Now, one of the CW1 has said that there were 300 students, but he does not say what is his source of knowledge. The LCR is before your lordships. As regards the CW3, who says that he was a student in the same tutorial class, he says there were 50 students only and 100 rupees per student. So 5,000 only. The learned tribunal has given a very, justly, my lords, has taken, my lords, in a way, my lords, more than what they have actually proved. Because if 5,000 was their earning, both of them, then 2,500 only. But it has taken 4,000 income for each of the persons. So there is no scope of interference as regards the income is concerned, lords. As regards the future prospects is concerned, lords, I bow down, lords, that would be governed by the Pranay Sethi. As regards the multiplier is concerned, there is no dispute. As regards the consortium is concerned, lords, since he was a bachelor, so 15,000 for funeral expenses, 15,000 for lords, in my respectful submission, for loss of estate. And lords, as regards the query of your lordships, as regards the sibling aspect is concerned,
yes,
Sarla Verma, lords, has been considered, approved, and applied. In fact, lords.
This amount has been paid to you?
My lord.
The amount
Yes,
has
my
been
lord.
paid?
Yes, my lords, my respectful submission is, my lords, my lords, as regards the interest is concerned, if your lordships may kindly appreciate, my lords, that the enhanced amount may carry interest, my lords, only, my lords, in my respectful submission.
The awarded amount has been paid, my lord.
That means 5,59,000 has been paid.
$549 plus 10.
59.
559.
16. Case of 2016. Yes, Mr. Lal, how much more do you want in this case?
My lord, so far consortium is concerned, the latest judgment that
Latest judgment?
multiplied by 3, my lord. And in Kulban Ansari case, because in Kulban Ansari arising out of our own High Court, in Supreme Court, that is, the parents are there, so 40,000 into 2 has been allowed, my lord. Therefore, under that situation,
A law laid down. It's a law laid down.
law is specifically not discussed here, but
In view of Pranay Shetty, which is a constitution-based judgment.
in Pranay Shetty case, 10% increase after every 3 years, that has also been.
How much more? Will you be satisfied with a more 4,50,000?
Let it be 5 lakhs.
Lump sum? I have increased 50,000. Yes, lump sum 4,50,000.
Yes,
Mr. Pratish.
My lords, since the income which was subject to your lordship's kind appreciation, lords, the income.
4,000. I have taken it to be 4,000.
Yes, 4,000 lords with 40%
Yes.
future prospects, multiplier of 18.
I am saying along with interest. Are you agreeable for 4,50,000 more lump sum?
Lords, if 4,000 is taken and 40% is applied and 18 is a multiplier is applied, lords, then it comes to around, lords, in my respectful submission, it comes to 6,34,000.
How?
4,000 multiplied by 12 divided by half.
No, not half. It will not be half. I'll not give
Yes,
half.
lords, it's unmarried. They settle law, lords.
I'll not give half. Go to the Supreme Court. I'll not give half.
Lordships,
unmarried sister. The entire liability of the unmarried sister is there.
but the father is there, lords. Achha, father is dead, lords. Perhaps the father is dead.
Father is dead.
Friend said that appellant number 1 is dead or what?
Yes.
Appellant number 1 is also dead. Appellant number 2 is also dead.
No, appellant number 2 is the daughter. I think mother was also there. She is dead.
She is also dead.
During the course of trial.
During the course of this.
So lordship says in the peculiar facts, lords, if lordship is saying that it should be 1/3, and if the amount is coming, if that amount is coming, lordships only. Lords, I have to calculate, lords, because I at the moment immediately, lords.
See para 37 of the Pranay Shetty judgments. There cannot be a straitjacket formula. If a brother is there who has father and mother to look after and there is an unmarried sister, you cannot say that he will squander all the money which he is earning. That 50% he is spending upon himself. In our society, it is, I don't agree with this. And the Honorable Supreme Court has also held in that line. If there are unmarried siblings are there, non-earning sisters or brothers, his personal living expenses may be restricted to 1/3. Tell me, Mr. Pratish Kumar.
Yes, Lords, I'm just calculating, Lords. I'm just checking, Lords. The amount is coming 9,07,200 plus as regards conventional head bloods, how much would be that?
70,000.
70,000. Lords, Lordship is granting, because he's the brother, so Lordship is granting filial consortium, I guess.
70,000. Whatever.
70,000. 70,000. So 9,77,200 Lords.
So,
and the awarded amount is
559.
559.
My Lord has said, including all interest, my Lord has suggested 4,50,000.
Yes,
including all.
He has not calculated correctly.
Yes, Your Lordships.
Are you agreeable for 4,50,000? During the course of argument, the council.
Yes, yes, Lord, it may be posted tomorrow, my Lords. I'll revert back to instruction.
I'm posting it next week. Mr. Arvind Lal submits that it will be, his client will be satisfied if a further amount of rupees 4,50,000 lump sum is paid to the claimants. First up. Next para. Mr. Pratish Kumar will seek instruction and inform this court accordingly. Let's discuss next week under the hearing for orders. Is this case on 28th February कर दीजिए 28th February. If you are ready to tell me, you come with a check on the Lok Adalat, the matter will be referred to the Lok Adalat.
Yes, yes, sir.
Now the next case, let us see what is the amount.
Lordship, in next case, I have misplaced my file, Lordship. I pay for 2 weeks time to.
I have not touched your case now. I have not reached serial number 22. Serial number 21. Yes, let me see the calculation. Where is it? Coaching Institute, the same. What was the income?
Same Lords, 4,000 has been taken and he was aged 26 years. He is survived by widow.
Widow and 5 and 2-year-old daughter.
Yes, two daughters.
Something more in this case, Mr. Something more in this case.
There are 4 dependents, Lords.
Mr. Lal?
My Lord.
How much in this case?
Lords, in this case, multiplier would be 17 applicable, Lords.
How much in this case?
Let the both cases be taken on 28th, my Lord. In the meantime.
The amount in this case, 1 lakh more? 1 lakh more, 5,50,000? Mr. Lal? 5,50,000?
Yes, it can be, my Lord.
Mr. Pratish Kumar, 50 in this case.
How much minutes more? 5,50,000.
Yes, 1 lakh more. Lump sum. 5,50,000 is this case on 28th.
Serial number 22, MA number 540 of 16, Mr. Shankar Lal Agrawal, Mr. Ajit Kumar Singh for the appellant.
Yes, Mr. Agarwal, what is this case?
Lordship, I misplaced my file, Lordship. I prefer 2 weeks time to reconstitute the same, Lordship. Last week I was,
Just a minute. Let me understand what is this.
50% of the awarded amount has been fixed upon the owner of the another vehicle, which had no license at all, with no insurance policy, Lordship. It was not insured. I am the owner of the truck.
You are owner of that vehicle which didn't have any insurance.
Lordship, correct.
Then pay them out. So what is the scope of this appeal? Let's see what.
I was also thinking on that line, Lordship.
Let's see. Who is for the respondents?
For the first time, Lordship, it has been listed, Lordship.
That is the misfortune. It has been listed after such a long period under the ring for admission.
My Lord may dispose of the matter, Lordship.
No. Let me understand first. And you say that I don't have any file, I prayed for time, and tomorrow your client will go and say that without giving me an opportunity, the order was passed. What is the age of the deceased?
About 28 years, Lordship.
28 years. Date of deceased was 28.
Lordship.
And you are the owner?
I am the owner of the truck, Lordship.
Kavita Roy. Okay. So there are two grounds mainly. The multiplier couldn't have been
multiplier, Lordship, only.
Multiplier could not have been 13. You say, I don't know from where you are saying the deceased was 49 years, not 29 years. So 13 is correct. And you say the vehicle was sold to one Laltu Sardar.
But I could not produce any document regarding that, Lordship.
So, not every. You don't have any paper, document. The case files are not with you. Mr. Agarwal, the case file is not with you. Mr. Agarwal, there's some problem.
Lordship.
The case file is not with you.
With me last week, I was going through the file. It appears that someone had taken away wrongly, Lordship, this file. Therefore, Lordship, I was.
Next week? Next week?
Last week was with me.
Next week?
Okay, Lordship. Lordship.
Mr. S.L. Agarwal submits that he has misplaced his file. First up, he prays to list this case next week. First up, let this case be listed next week.
Serial number 23, MN number 545 of 16, Mr. Vilas Sinha for the appellant, Mr. Gautam Kumar, Mr. Sandeep Kumar Agrawal, Mr. Vilas Kumar, Mr. Azadul Haq for the respondent.
This is an appeal by the insurance company.
Yes.
Let's may straight away come to the award. At page 2 is the manner of accident. There is no other vehicle involved.
Yes.
As there is no other vehicle involved, my lords may come to para 2 of the impugn award.
Para 2 of the impugn award, yes.
Yes, manner of accident. The fact of the case in brief is that the deceased Septu Sheikh alias Septu Sheikh was 26 years old, who was the licensed expert tractor driver. He worked as a tractor driver number such and such of his village co-villager Manoj Kumar Bhagat on a monthly payment of rupees 7,500. On 28/4/2011, some mechanical defect caused in the self of the tractor, and Septu Sheikh alias Septu Sheikh requested the owner to repair the defects, but the defects was not removed, and the tractor was being started by directly attaching the connection battery to the engine through wire on the direction of the owner. It is stated on 30/4/2011, Septu Sheikh stopped the tractor like other days near his house of the Ajit Tiwari in Natural. He put some stone against the wheel of the tractor and went home. On 1/5/2011, he again started the tractor attaching the wire, but the tractor was put in gear and the wheel stone was removed by the owner without information to him, due to which tractor suddenly moved forward and Septu Sheikh alias Septu Sheikh came under the tractor, and due to injury he died on spot. Now my lords may come to paragraph 15 and 22.
Yes.
Paragraph 15, Exhibit 2 is a charge sheet. After investigation, final report has been submitted in this case showing the driver of the tractor negligent for the accident. Paragraph 22, Exhibit 11 of the report of the IO, it is stated that deceased was the driver of the tractor who died due to the accident caused by his own negligence. The accident is solely contributed by the deceased himself.
Anyone is appearing on behalf of the opposite party? Notices have been issued.
Lordship, for claimants, I am appearing.
For claimants, you are appearing.
My lord.
Yes. Who is for the owner?
They are down.
You are appearing?
Yes, sir.
As my first submission is that the claimants are not entitled for any relief because the MSCT claims are based on the law of tort. A wrongdoer cannot take advantage of his own wrong. There is no contrary evidence brought on record that the accident was not caused by the own mistake of the Septu Sheikh. Rather, there is a police investigation and a report of the investigating officer. So how can a person who himself has contributed for the accident, or rather we can say who himself is solely responsible for the accident, he can ask a tribunal to get an award for that? And this is what the Honorable Supreme Court has said, has my lords discussed in 2018 9 SCC 801, when they paragraph 7, when there is no other vehicle is responsible for the accident, and the person who the legal heirs of the deceased are claiming, then considering law of tort, the Honorable Supreme Court said they are not entitled even for a single penny. And here in this case, my lords, the towards my lords, 2,25,000 is allowed towards loss of affection and burial expenses and loss of state.
Yes, Mr. Gautam Kumar, what is your argument?
Yes, my lord. So far, Lordship, the aforesaid submission of Mr. Sinha is concerned. Lordship, it is the case as admittedly it is a case of an accident. And the deceased died out of an accident, though it was taken place due to some mechanical defect. But it is an accident. It is an accident, and the evidences are there that the deceased died due to the accident.
Accident cause, who is the wrongdoer? Accident caused because of whom?
But Lordship, wrongdoer exact that is not been given who is the wrongdoer. That is correct, Lordship. But the accident taken place from the said tractor, and the tractor was very much insured.
Yes.
So Lordship, insurance company was liable to pay the insurance because it is the tractor due to the.
What is the judgment you are referring to, Mr. Sinha?
It is 2018, volume 9, SCC, page 801, paragraph 7. The earlier judgment, that is 2007-9 SCC 263 is followed in this case. Paragraph 7, I am reading, my lords. We have carefully considered the submission of the learned counsel made at bar and perused the material placed on record. It is an admitted position that the deceased was the owner cum driver of the vehicle in question. The accident had occurred due to the rash and negligent driving of the vehicle of the deceased. No other vehicle was involved in the accident. The deceased himself was responsible for the accident. The deceased was the victim of his own action of rash and negligent driving. A claimant, in our view, cannot maintain a claim on the basis of his own fault or the negligence and argue that even when he himself may have caused the accident on account of his own rash and negligent driving, he can nevertheless make the insurance company to pay the same. Therefore, the respondents, being the legal representative of the deceased, could not have maintained the claim petition filed under section 166 of the MV Act.
Paragraph 7.
Paragraph 7, my lords.
Yes, what do you say about this judgment?
That's the complexity in this case is at the time of stay, I have deposited 8 lakh rupees, out of which, my lords, 11 lakh rupees, out of which they have 8 lakhs they have already taken. That also, I think, my lord, I have to bring to the knowledge of the court.
The fine distinction is, in the case which we have referred, it is the owner cum driver who was driving.
Yes.
Over here, he is the driver. He is not the owner cum driver.
Yes, that is true, my lord. But the principle remains the same.
The Honorable Supreme Court says the deceased cannot be said to be a third party.
But here also, if a third party, my lords, will come in front of the vehicle directly.
This person, this claimant could have filed a case under the Workmen's Compensation Act also.
That would have been a different case if he had filed a case under Workmen Compensation.
Tell me, what would have been if you would have filed a case under the Workmen's Compensation Act? Let me understand.
My lords, may repeat once again. I could not.
Tell me what would be the effect if the case would have been filed under the Employees Compensation Act?
My lords, if it is filed under the provisions of Employees Compensation Act, then it has to be seen whether the death has occurred arising out of or in course of employment or not, or whether he has willfully contributed there also, whether he has willfully contributed for such accident or not in violation of any statutory guideline. Here, 166 is based on the principle of negligence. There is a difference between 163A and 166. 163A is a pure structural formula where, my lords, there are Supreme Court judgment that negligence is not required to be seen.
Not required to be seen.
166 is a question of negligence, and from there the tortious liability, my lords, creates on the person who has committed wrong. Here also, who is the wrongdoer? If he is the wrongdoer, then how can a person claim benefit arising out of his own mistake? And if not, some part may be deducted for own contribution.
No, tell me if it was a case under section 163A.
166 it is, 163A.
No, if it would have been, then what would have been the effect? What would be the effect?
My lords, 163A is akin to 140. No fault liability. I can show my lord judgment.
Yes.
Here I cannot raise all these points, and there he will not get multiplier of 40. He will not get 9 lakh rupees. He will get 3 or 4 lakh.
He will get?
He will get hardly 2 to 3 lakh on the structural formula, which is akin to 1.
How will you get 4 lakh?
Well, the schedule is prescribed in the MSCT itself.
Yes.
From their calculation and the
from that, how much you will be getting?
But today I will say we cannot argue on this point because it will amount to change the entire proceeding.
I'm asking you. I'm just asking.
But I have to calculate. It will not go more than 3 to 4 lakhs. I am saying as per my experience.
Because the schedule is unamended till date.
Yes, it will not go more than 2 to 3 lakhs. So I propose, my lords, a practical solution can be a reasonable sum can be deducted 20 to 25,000, 25% arising out of the corrected assessment, because assessment is also wrong. If my lords always have a discretion looking into this fact of the case, that they have already taken 8 lakh.
Yes, Mr. Gautam Kumar, you argue.
Yes, my lord. Lordship, what I have earlier submitted, that lordship, this my submission still exists, that it is the tractor is the offended tractor, and due to defect or mechanical issue or any other issue, but it was an accidental death.
Mr. B, it may be an accident. No one is denying the accident. Mr. Bibas Sinha is relying upon this judgment and saying that this judgment holds that when the wrongdoer cannot be allowed to take benefit of his own wrong, so you're not entitled to receive the amount. You're not. This application is not maintainable. You distinguish this judgment. You formulate your point of law. You revert this. It's merely saying that the accident has taken place, so I'm entitled. This is not an argument worth consideration.
Lordship, since Lordship, this was the issue, and even the learned court below has also held to that point what I am submitting. And now Mr. Sinha has raised this point. Then
you are submitting what the court has held. It is not what the court, what you are submitting the court has held. Please raise the quality of your argument.
Let it to be next to I will set some work out on that point. Then I will.
It is relied upon the judgment. Nikita, heard Mr. Bibas Sinha. Mr. Bibas Sinha appearing on behalf of the appellant submits that considering the nature and the manner how the accident has occurred, the claimant's claim application filed under section 166 of the Motor Vehicle Act is not maintainable. First of all, he submits that it is the deceased who was at fault and no other vehicle was involved in the accident. He submit when the deceased, the driver was at fault and there been no other vehicle involved in the accident, the deceased, the claim application under section 166 of the MV Act is not maintainable as the deceased cannot take benefit of his own wrong and rash act. First up, in support of his claim, in support of his contention, he has relied upon a judgment of the Honorable Supreme Court of India in the case of National Insurance Company Limited versus Ashalata Bhumik, as reported in 2018, Volume 9 SCC, page 801, bracket paragraph 7. Next paragraph. At this juncture, Mr. Gautam Kumar appearing on behalf of the claimants. And yes, Mr. Durgacharan Mishra, what do you have to say? You are the owner of the vehicle.
But in this case, vehicle in question was insured. And, this is due to negligence of.
At this stage, Mr. Gautam Kumar, counsel appearing on behalf of the claimant, please for some time. Next paragraph. Considering the issue involved in this case, this appeal will be heard. Admit no further notice needs to be issued as the parties have already appeared. Parties have already appeared and the local court record is already available.
Obligement.
Policy covers the driver, Mr. Bibas Sinha?
Yes, policy covers the driver. Policy covers the, but they may talk to us for a settlement also in this case, because we also know that ultimately we are not going to get money back from them. Some sort of settlement if they want, Mr. Gautam and I can talk with each other and then we will propose to the court.
Question is, what is the status of a driver in this insurance policy? In the insurance policy, the contract of insurance,
yes,
the status of this driver is a first party, second party, third party, what party?
Well, it's whatever. If I am a third party, admittedly, and I
just don't jump. Plus, look, first give me this reply. You may say that he is responsible, so there should be an apportionment. I'm asking you whether he's a first party, second party, or third party.
But it's if he is a paid driver covered under the policy, obviously third party.
He's a third party. So the judgment which you have cited can be distinguished.
But that then, my lords, at that time of hearing, I will come up with the judgments of 166, its scope, question of answer of point of negligence, and then only award can be passed. This is for the purpose of admission hearing. I will come up with other judgments also.
Yes. The extent of negligence of each of the parties is also to be seen.
Yes. Yes.
If this person is a third party, and if there is an extent, if there is 100%, then it's different. But if there is 50%,
yes, 25% also, 25% also. That can also.
So I'm saying that this judgment can be distinguished. The judgment of the Honorable Supreme Court, which you are.
Yes.
Let's see what the appellant argues and what cue he gets.
I'll also try my best to search out something of that.
Even without searching out, you can distinguish the judgments. Yes, next.
Serial number 24, MA number 55060, Mr. Arvind Kumar Lal from Barbelan, Ms. Satta Bola, Mr. Manish Kumar, Mr. Abhishek Mishra, for the respondent.
Lord, in this case, there is right of recovery in favor of the insurance company. On the last date, my lords, my friend Mr. Vibhas Sinha was arguing that the right of recovery.
This is the case of Mr. Arvind.
Yes,
Kumar.
yes. My lord. He has come for enhancement, my lords, and there is right of recovery in favor of the insurance company, my lords. On the last occasion, my lords, Mr. Vibhas Kumar Sinha was arguing that right of recovery was given only because, my lords, the registration certificate of the vehicle was found to be valid for only 2 years, which is irregular vehicle registration is valid for 15 years, and on that ground, right of recovery is not sustainable. He was saying that even though appeal has not been filed by the owner, this point he can take because a point of law. Thereafter, LCR was called for. Now, my lords, I have gone through the order, my lord. Right of recovery has not been given on the ground that the vehicle registration was valid for only 2 years. Right of recovery has been given because no document was produced by the owner of the vehicle before the Learned Claim Tribunal, which is violation of section 147(2). And there is specific petition mentioned in our written statement at paragraph 6, 7, 17, and 18. That, my lords, 6 and 7 it is mentioned that they be directed to produce, and in 17, 18 it is clearly mentioned that the vehicle was being applied on the basis of not valid documents. Therefore, the recovery right in favor of the company is just and proper in view of the judgment of Amrit Pal and Pappu case, my lords. Once we have taken a specific plea, and that all the documents were produced except the driving license of the driver and the permit of the vehicle, my lords. So if my friend is, without filing appeal, if he is arguing that since it is a error of fact, therefore the right to recovery is not sustainable, in that case, my lords, he may be asked to produce all the vehicular documents also. Because that is the ground for which recovery right has been given. If my lord will permit me, I'll place only that particular paragraph, my lord. That is at, my lords, issue number, my lords.
Page 6, my lords.
Issue number 5, my lords. Page number 6 onwards. And, my lords, the relevant portion is on page 7. I'll place only page 7 only, my lords, in support of my contention. If my lord,
my request would be that page in
let me
number 5, one para DL is mentioned here, sir.
थोड़ा पढ़ने दिया जाए एक बार, उसके बाद आप पढ़िएगा. Just एक paragraph से page 7 का हमको पढ़ने दिया जाए, my lords. That will clarify the issue.
Yes.
Page 7 का start ही हो रहा, my lords. Mentioned as 20th September 2000. This is about the registration certificate, my lords. The last line of the, my lords, page number 6 will be, it transpires that validity of the registration of the said offending vehicle has been mentioned as 20th September 2012, whereas the alleged accident took place on 21/1/2013. As such, on the alleged date of accident, the said offending vehicle was not valid and genuine. As discussed above, no any sheet of paper regarding the said offending vehicle has been filed or proved on behalf of the opposite party. So this was being, my lords, taken to be that registration certificate cannot be valid for only 2 years because the vehicle was purchased in the year 2011. Now, next paragraph I am reading. Further, it appears from perusal of, here, my lord, which I just read, nothing has been mentioned with regard to right of recovery. Next paragraph I am reading. Further, it appears from perusal of photocopy of insurance policy marked X/2 for identification, filed on behalf of the claimant that offending vehicle was insured from 6 to 12 to midnight of 5 to 13, and alleged accident was taken place on 21/1/2013. Hence, at the time of the alleged accident, the said vehicle was duly insured under the policy cover of the National Insurance Company Limited, OP number 3. No any vehicular document.
Mr. Sinha, just tell me one thing.
Yes.
What is right, what is wrong, what should have been, what could have been, I don't know.
But may I only read 5 lines? Only 5 lines. He is reading part of that and he is not referred the earlier portion. Kindly, kindly come to issue number 5. Every document is there. Even if I have not brought on record, I am just reading. My lords may kindly appreciate. It appears upon service of summons, OP number 1, owner of the offending vehicle bearing registration number such and such, and the driver of the vehicle appeared in this case, filed a written statement, but no oral and documentary evidence is produced on their behalf, accepted. Further, from perusal of case record, it transpired that on behalf of the claimant, some of the document relating to offending vehicle has been filed in this case. Now, my lords, the photocopy of certificate of registration of the vehicle filed on behalf of the claimant. Next, which is marked X, further photocopy of driving license of driver of Vijay Kumar Saw marked as Exhibit X/1 for identification. Photocopy of insurance policy marked as Exhibit X/2 for identification. But from the perusal of photocopy of certificate of registration of the offending vehicle, it transpires that the vehicle of registration of the said offending vehicle is mentioned as 20th September 2012, whereas alleged accident took place on 21/1/2013. As such, on the date of alleged accident, the said offending vehicle was not valid and genuine as discussed above. No sheet of paper of. Yes, I have not produced. But what today I am arguing, it is the plaintiff who has produced it. These are the documents which are available on record. What has stopped the insurance company to controvert it? It might be a possible, my lords, that I am a poor person. I cannot participate proceeding each and every date. I have given all these documents to the claimant. How can an insurance company, being a public sector undertaking, can say that although these documents are available on record, and today they are not arguing that registration can't be for a 2-year? It's an absolute wrong finding given to me. And this is the
permit.
right of recovery against me.
Permit
Just,
कहाँ है?
no, just a minute. The registration, the document which is there, it suggests that the registration is up to 20th September 2012. When did the accident had taken place?
That accident has taken place on 21/1/2013.
So it was beyond the date of registration then?
My lords, it can't be. I am just submitting, my lords. The vehicle is purchased on 2013, 2010.
Yes.
That is, the accident report is also a part of LCR. It is 2010 vehicle. It can't be 2012.
The registration document is with me. It says 2012.
Perhaps that may be the fitness, my lord. For new vehicle, fitness is for 2 years. And every 6 months or 1 year, thereafter it is renewed. But that cannot be said that fitness is not registration.
Mr. Lal, this is a you have got nothing to do in this dispute. Please don't put your foot in.
But that is not with me, my lord. If that is there and it is.
Certificate of registration, Jharkhand State. Registration number JH15F8997. Unladen weight 2500. Cubic weight 2956. Wheelbase 2750. Date of registration 25th September 2010. Manufactured by Tata Motors. Fuel diesel. Vehicle class LGV1. Body type pickup. Sitting capacity 3. Standing capacity 0. Date of manufacture 2010. Chassis number so and so. Engine number so and so. Model number so and so. Tax paid up to, listen to this. Tax paid up to 23rd of December 2010. Registration validity up to 20th September 2012. There is nothing on record to suggest that it has been renewed, extended.
That I cannot improve. I cannot improve. I can only argue what was before the tribunal at that point of time, since I have not filed appeal.
This is before the tribunal.
Yes.
20th September 2012 maybe.
If that is there, well, I have to accept. I can't argue with it.
Maybe an error on recording, but we cannot presume or assume what is there.
Since I have not filed cross appeal, my jurisdiction, my point of argument is very limited. And what I have submitted, I cannot travel beyond that. Law will not change for me.
So,
but it will go against me.
Now, so far as enhancement.
My lord.
Yes, what are the grounds of enhancing this amount?
In this case, my lord, the deceased was a mason. Age was 33 years old.
Yes.
And our claim was that he was earning 9,000 rupees per month, but the learned court below has considered it as 6,000 per month.
Let
There is
us
no
see.
concern.
Let us see. Let us see. What is the material evidence? What was the minimum wages at that point of time? Date of accident?
Minimum
Date of
date of
accident?
accident is 21st January 13.
Minimum wage notification 2013. Date of accident is 25.
21st January 13.
So notification सब थोड़ा सा आ गया और मोटा पूरा 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 bunch. तो 2021 का notification, 13 का notification, 2013 का.
My humble submission, my lord, that
Yes.
minimum wages, so far earning is concerned, minimum wages cannot be restricted. He can be able to earn more, my lord. It cannot be less than minimum wages. And 9,000 rupees, I have given the evidence, no cross exemption on that point by any of the opposite parties. No contrary evidence.
9,000 rupees. There is nothing on record to substantiate what you have said.
My lord. But in evidence it has come that he was earning 9,000,
Well,
no cross
somebody
exemption on that point.
earning 9,000. That is not enough. The court has to assess
My lord.
based on the evidence. Let us see what is the evidence which you have led.
My lord. Witness number 1, Yashoda Devi. एविडेंस पैरा 4 माय लॉर्ड, यह कि दुर्घटना के समय मेरे पति की उम्र 33 वर्ष थी, वे अति निपुण राजमिस्त्री थे, उनकी मासिक आय 9,000 रुपया महीना थी, कुछ ही वर्षों में उनकी आय दुगनी हो जाती. नाउ देयर आफ्टर क्रॉस एग्जामिनेशन माय लॉर्ड बाय नेशनल इंश्योरेंस कंपनी. मैं अपने पति के जन्म का तारीख महीना नहीं बता सकती, दुर्घटना के बारे में मेरे आंखों देखा कोई जानकारी नहीं है. मेरे पति का आमदनी का हिसाब किताब मेरे पास घर में है, मैं दाखिल कर सकती हूँ, ऐसी बात नहीं. मेरे पति उम्र आमदनी और व्यवसाय गलत बताया, ऐसी बात नहीं. मेरे पति अपने लापरवाही के कारण सड़क पर आ गया, मेरा पुलिस के सामने कोई गवाही नहीं हुआ है.
Mr. They have challenged that. They have challenged that you are earning 9,000 rupees, to which you say that you can produce those documents. There are documents. You have not produced these documents. They have challenged that.
But they have not even given a suggestion that see 9,000 rupees is not the income.
No, it is. Well, yes, they have said your income is not 9,000. So that is why you have said that no, my income is 9,000. I have my documents to show.
My lord.
Then
Other witnesses also, my lord, they have said 9,000 means around 300 rupees per day for the Raj Mistri.
So that is actually wages.
Yes, my lord.
They have controverted. There was even a suggestion that he was a mere labor working under OP number 2. OP, no, not OP, PW number 2.
Raj Mistry is also a level, but qualified level.
What are you saying?
Raj Mistry is a qualified level working as Raj Mistry.
Mason is a skilled work.
My lord.
Work Mason is a skilled work. His skill is immense.
Witness number 3, my lord, Varun Mandal.
I have seen
He
that.
has said,
I have seen that. I've seen this paragraph 3, 4. I have seen that. Very good.
my lord.
Yes, now tell me. What is the age of the deceased?
33 years,
Multiply 70.
my lord.
That should have been 16, my lords. As per Sarla.
It will finally, as per pernickety, will come to 12,79,600.
12,79,600.
6,000 into 12 will become 72,000.
Yes, my lord. 40% future
40% will be the future prospect, which will be 28,800, and
12 lakhs. 12 lakhs.
79,600.
Yes,
Plus consortium conventional heads.
I'm waiting after adding that. Else it will come 12 lakh 9,600, 70,000 will be added, then 12 lakh
923 has been given.
Yes, ma'am. 933.
Nine lakh 33.
Yes, ma'am. Difference will be 2,76,600.
No, 3 lakh 46.
Yes, I'm sorry.
If tenacity is taken into consideration, my lord, then 10% in conventional head has to be added, my lord. That is 77,000 now.
Award is dated?
Is 29/6/16.
Yes. Mr. Lal, how much more do you want?
It depends upon the amount of salary what my lord is considering, whether it is 9,000 or 6,000.
6,000, 6,000. But there's nothing to suggest.
It can be more, my lord.
I'm not getting any evidence to that effect from your side.
Then, my lord, future prospect and conventional heads.
4,75,000 more? 4,70,000 it's coming to.
And interest, my lord.
Including
Is
interest.
Some amount to be added.
Including interest. Interest coming to 1,21,000 on the balance amount at the rate of 4%.
Let it be 5,30,000 था बढ़ा दिया जाए, ज़्यादा नहीं बोल रहे हैं. My request is
4,60,000. It's 4,67,000. I am saying 4,70,000. It is coming to 4,70,000.
My humble request is let it be 5 lakhs, my lord. Only 20,000-30,000 rupees is nothing for insurance company, but for my client, it will be a boon for them.
Vivasena, you cannot. Tell me.
As they will recover from me through process of court. Right now.
No, so for right of recovery, but as per you, what would be the correct amount? If now the right of recovery, the question is, can there be a settlement without you?
As there cannot be a settlement without me, and I cannot consent for settlement because my clients will never authorize me for that.
Yes.
That is the difficulty. So better my lord may dispose it of in terms of merits.
It's better it is decided.
Yes, better it would be decided by.
Heard the counsel for the appellant, heard the counsel appearing on behalf of the insurance company, and heard the counsel appearing on behalf of the owner of the vehicle. Stop. In this appeal referred against The judgment award dated so and so past so and so. The claimants are praying for enhancements of the compensation amount. Full stop. Next paragraph. The learned counsel, Mr. Arvind Lal, appearing on behalf of the claimants, submits that the tribunal has wrongly assessed the income of the deceased at rupees 9,000 per month. He submits that there is a consistent evidence to the effect that the deceased was a mason and was earning rupees 300 to 350 rupees per month, per day. He submits that the witnesses have categorically stated that the deceased was a mason, and some of the witnesses have stated that they have worked under him. First up, he submits that the wife of the deceased stated that the deceased was earning rupees 9,000 per month. First up, he further submits that the amount of compensation has not been awarded in terms of the judgment of the Honorable Supreme Court of India as decided in the case of Pranay Shetty so and so so and so. Full stop. Next paragraph. The counsel appearing on behalf of the insurance company submits that a right of recovery has been given to the insurance company as the tribunal has held that there was a violation of the terms and conditions of the policy. He submits that the vehicle was registered, the registration of the vehicle was valid till 20th September 2012, whereas the accident has taken place on 21/1/2013. He submits that even if the vehicle was insured by the insurance company, the vehicle was not supposed to be plied on road beyond 20th September 2012. He submits that this being a fundamental breach, the insurance, the right of recovery has been granted. He submits that so far as the income of the deceased is concerned, the oral evidence is contradictory, and there is nothing on record to suggest that the deceased was earning 9,000 rupees per month. First up, next paragraph. Mr. Vibhas Sinha, appearing on behalf of the owner of the vehicle, submits that a registration of the vehicle of a vehicle remains valid for a period of 15 years. He submits that admittedly the vehicle was purchased in the year 2010, and that being so, the registration of the vehicle is valid for till 2015. Thus, the insurance company is entitled to indemnify the owner of the vehicle. First up. After hearing the counsel for the parties and after going through the lower court records, I find that this appeal is confined only to the quantum. First, next paragraph. So far as the contention of the learned counsel for the owner is concerned, I find that the owner did not produce any document before the tribunal. Yet, photocopies of some of the documents in respect of the vehicle are on record and has been relied upon by the tribunal. First up. From the photocopy of the registration certificate, which is marked as Exhibit X for identification, I find that the registration of the offending vehicle bearing registration number JH11F 8997, is it the correct number? '8997.
JH11F
was registered was registered on 24th September 2010. But surprisingly, the registration validity date has been mentioned as 20th September 2012. Full stop. Further, I see from the document that the date of manufacture, the year of manufacture of the vehicle is 2010. Full stop. Mr. Bibhas Sinha submitted that a new vehicle is registered for 15 years. Full stop. But the document which has been produced in this case clearly suggests that the vehicle was registered. The validity of the registration is till 20th September 2012. Full stop. This court cannot go beyond this document, which has been admitted by the parties. Even if the recording is erroneous, but for the purpose, this recording is this recording of the date, that is 20th September 2012, is conclusive so far as this case is concerned. There is nothing to suggest that this date was rectified or corrected later on. Full stop. In absence of any other supporting documents, this court cannot go beyond the findings which has been recorded. Thus, thus I find that no error has been caused by the tribunal in holding that since the accident has taken place on 21/1/2013, there is a violation of the condition of policy, as the registration of the vehicle expired on 21st September 2012. First stop. Next part. Now, since the registration of the vehicle expired at the time since the registration of the vehicle had already expired much prior to the date of the accident, the tribunal has rightly granted the right to recover the amount from the owner of the vehicle. Next slide. The main question in this appeal is what would be the quantum? First up. The counsel appearing on behalf of the appellant dispute the quantification of the compensation amount. It is his case that the claimant was earning rupees 3,000 per month, rupees 9,000 per month, but the court has wrongly assessed the amount to be 6,000 per month. Tell me, what is the minimum wages of Mason at that point of time?
I'm not aware, my lord.
2013. How much? Mason. Building construction, देखिए. First up. Admittedly, there is no documentary evidence in support of the income. First up. The only evidence which is available are the deposition of the witnesses. First up. PW1 is the claimant herself, who is the widow of the deceased. She, in paragraph 4, has stated that the deceased was working as a mason and was earning 9,000 rupees a month. Full stop. In cross-examination, the aforesaid contention was controverted and to which she submitted that she has got the details. She has kept the accounts of the income. She have kept the details of the income of the deceased in her house, and she can produce the same. Comma, but the said documents admittedly was not produced. Full stop. PW number 2 is the brother of the deceased, who also stated that the deceased was a mason and was earning rupees 320 to 350 per month. Full stop. This content of this PW number 2 was also controverted. And a suggestion was given to this PW to the effect that the deceased was working as a mere laborer under PW number 2, as PW number 2 is a mason. Full stop. Similar is the statement of PW number 3 and PW number 4, who claimed that they worked under him at some point of time, and he was a very efficient mason, a very efficient and sought after mason. Full stop. Thus, from the oral evidence, it is thus there is only some oral evidence which was also objected, which also objected by the insurance company on the point of income of the deceased. Full stop. Two 2013. Let's see. Construction business. Let us.
It's online. If I can check, it is at serial number 31. Construction, maintenance, and other work is 212 rupees 97 paise.
Skilled or semi-skilled or unskilled?
No, this is skilled, and another category is highly skilled. That is more unskilled, skilled, and highly skilled. At column number 31, at as per the
what you are reading?
Well, that is
what
the serial 31 of
which document?
Well, that is right now on the website. I can check. That is minimum wages in Jharkhand with effect from 1st October 2013 to March 31st March 2014. There at column number 31.
इसमें अक्टूबर 12 से मार्च 13 तक का चलेगा।
हाँ, वो
it will be a difference of 10 to 12 rupees there. There has to be some.
So as per this, it appears 212.97 or
something. Multiplied by 26, my lords.
Yes.
So assessment is correct, my lord, 6,000.
Find out. Jharkhand government notification.
Yes, madam.
Minimum wages. क्या लिखा? Full stop. Thus, from the oral evidence, one thing is evident that the deceased was a mason. Full stop. If that be so, now the court has to assess as to what would be the income. Full stop. In absence of any cogent evidence, the best way to assess the income is to see what was the income of the deceased. Is a mason. What was the minimum wages of a mason at the relevant point of time? Full stop. The notification of the government dated so and so notifies that the minimum wages of skilled labor is so and so blank. I'll take it out. Full stop. Thus, safely it can be construed that the mason who is a skilled labor was earning rupees ... per day. Full stop. Now, for the purpose of quantifying the monthly income, the said daily income should be multiplied into 26. Thus, the amount will come to so and so. Full stop. The compensation has to be calculated in terms of the judgment passed by the Honorable Supreme Court of India in the case of Pranay Shetty and others. Full stop. The deceased, next part, the deceased was aged about
33 years.
33 years. Full stop. The multiplier would be 16. Full stop. The deceased was left behind six dependents.
So 1/4 will be destroyed.
The deduction on account of personal expenses would be 1/4. Further, from the impute judgment, I find that no future prospect has been added for the purpose of calculation of the compensation. Full stop. Since the deceased was self-employment and was below 40 years, 40% enhancement has to be awarded on account of future prospect in terms of the judgment passed by Pranay Shetty and others. Full stop. So far as compensation on account of conventional head is concerned, this is the accident of 2013.
Yes, my lord. 2013, January 2013.
70,000 rupees has to be added.
My praise is 77, my lord.
How?
Pranay Shetty judgment after 3 years, 10% has to be increased, my lord.
3 years of what? 3 years from what?
2017 is the Pranay Shetty judgment. Thereafter, even 3 years has been passed.
that is 3 years from the date of death.
No,
Or from the
पेनेसिटी को लिया जाए तो पेनेसिटी के बाद भी तो 3 साल बीत गया.
No, expenses of funeral, the funeral expenses which had already spent in 2013, that cannot be increased because it is already spent.
That is correct, my lord.
So let it be 70,000 in appropriate case. We will decide 70,000 for the start. Thus, on recalculation, comes to so and so. Full stop. The tribunal has awarded compensation to the tune of rupees 9,33,000. Full stop. Thus, the balance amount of so and so is to be paid by the insurance company, along with the interest at the rate of 7% per annum from the date of the award, that is 29/6/2016, till this balance is paid. Full stop. The insurance company is directed, insurance company will be at liberty to recover the amount from the owner of the vehicle. This additional amount from the owner of the vehicle. Full stop. This appeal is this allowed to the aforesaid extent.
Some you may kindly be prescribed, my lord, for the payment.
लिखिए मिला लिख दीजिए the amount by what time?
My lord, reasonable time, my lord, 6 weeks.
Within 6 weeks.
My lord.
This is a notification, column 31. Okay. Column 31. How much it is? Mr. Sinha, which you are referring?
Serial number 31, column 31.
What is the amount?
It's column 31 shows minutes. Just a second. Column 31 shows amount construction or maintenance of road building construction. It is 212 rupees 97 paise for skilled. And if it is highly skilled, then the question would be 212.97 paisa.
Give me the notification.
I have sent to the court master that notification.
So 31 you sent a notification which says 127, 40 plus 167, 134, 40, 174, 163.
But it has got different columns for skill, unskilled, and semi-skilled. Construction, it's 174, 163, and VDA will be added with 49.97 and will come 212 rupees 97 paisa.
Shalal.
My lord.
You can also verify once. No difficulty.
Okay, I'll see. I'll check it.
6 weeks time, my lords.
Mr. Lal, if I take 2112 and multiply it by 26, then it will come to less than 6,000. But I'll take care of it. Don't worry.
Just and proper, my lords. If it is reduced in that case,
I'll take care. I'll take care of it. The reduction will not be there. Don't worry.
Yes.
I'll not reduce it. Huh? Paid within 8 weeks from today.
Obliged.
Yes, next. Draft. Bring a draft. Yes, next.
Serial number 25, ML number 564 of 16, AS 30 meter
Yes.
Lord, I have come for enhancement, my lord. This appeal is by the claimants, the wife and children of the deceased. My lord, the income was claimed as 5,000. The age was claimed as 45 years. The tribunal has assessed the income itself to be 3,000 per month.
Why? What was your occupation, profession, vocation?
He was a pickup tempo driver.
This is the only ground.
Yes. Another loss of future prospect has also not been given.
5,000. You claimed. What is the age?
45 years.
Multiplier?
14 has been applied. 12, 14. Multiplier of 14 has been applied.
45 years, US.
I'm sorry, my lord, 43 years. It was 43. I'm sorry, 43 years.
So multiplier is same.
Yes.
How many dependents?
2 minors, and at that point of time, one is still minor.
No. It will be at the cutoff date.
Yes.
Will be the date of
There
the
is
accident.
3 dependents, 1/3 will be deducted. As per calculation, he will get 7,70,000.
Seven lakh 70,000.
Yes.
How much paid?
As we have
4,16,000.
Yes.
4,16,000.
4,60,000.
16. Page 23, para 10.
Yes, how much more? Mr. P.S. Pati?
My lord, I had claimed around 11 lakhs. 11 lakh 35,000.
More?
No, altogether before the learned.
I'm asking you more.
More, as per the calculation, round off कर दिया जाता है जो इसको. Around 10 lakhs total कर देने से.
5 lakhs more, Mr. Sinha?
My lords, there will be one difficulty with us. Therefore, I am requesting my lords may come to page 22. My lords,
Yes.
Indirectly itself, but right of recovery is given to us. So I am
Yes.
saying, my lords, page 22 of memo of appeal, running page 4. Citing a overruled judgment, right of recovery is given to us. So, my lords, it will be very difficult for us to make settlement in this case. My lord has to. Yeah, that my lords may come to page 4, turning page 4 of the award, running page 22 of the memo of appeal.
Last 4 lines.
Yes.
Rather middle of that. In this case, driving license of the deceased driver has also been marked as Exhibit 4. And as per license, deceased was entitled to drive LMV from perusal of driving license. It transpired that there is no endorsement for driving
No,
transport
no,
vehicle.
this is absolutely wrong. This judgment in view of what is the latest judgment?
Yes, that is 2017-14 SCC 663. It is an overruled judgment, but right of recovery given.
17-14-663.
Yes, paragraph would be paragraph 53. Paragraph 53. This. So my lords may decide. Therefore, that will be difficulty for us. Owner has not come. Right is there. How can we?
No, owner is not coming. There is no right. There is no right. Make them understand there is no right. I have calculated this amount 5 lakh. It comes to 5 lakh 2,000. Considering interest at 7%. If I have to decide, it will be 9% from the date of filing.
Okay. So my lords, how much? 5 lakh is my lord is saying.
Balance 2% you will be saving from 2016. On this 3 lakh 54, you will be saving 2%.
My lords, can it be on Monday? I will take instruction. Can it be on Monday? I will take instruction.
Yes. Because as per this latest judgment, you cannot recover.
Yeah, that is, my lord, and that is also the difficulty how to find out way for settlement. Because right or wrong, there is a tribunal's order where right of recovery is with us. Bypassing that, saying they have asked me for the opinion. I have given writing in opinion that in view of this 1714, no right of recovery subsists. But still, they have got some problem. Anyway, I am again talking to them. Or if genuinely they can't do, I will say to the court to pass an order. Because it is catch 19 position for them. Only till Monday, brothers. Monday, I will.
Is this case on Monday? Yes, Mr. Pati, you also asked your client.
Well, 5 lakh altogether.
Altogether.
Lump sum.
What has been paid over and above now 5 lakh? Final amount. Yes, I'll take instruction.
Obliged.
Yes. Next.
Serial number 26, MA number 565 of 16. Mr. Arvind Kumar Lal, Ms. Madhurika Das Gupta.
This appeal is also for enhancement, my lord.
Yes.
This was 27 years old. He was a hawker of selling saris and other clothing, my lord. And our claim was that he was earning 15,000 rupees per month, but the court has given a finding about 7,000 rupees. Future prospect not allowed. Deduction 1/4 is correct. Multiplier is also correct, my lord. But funeral expenses state has been given only 15,000, no consortium. The date of part, not from the date of making.
Yes.
Interest from the date of award has been allowed, but not from the date of making application.
Right.
Region has been assigned.
Region has been assigned.
No.
Yes, here is here.
This order in the last paragraph of internal test.
Yes. Yes, what is the evidence of your income?
Income is 15,000, my lord. And regarding salesman, hawker, and no such document is there, my lord.
Hawker means?
Hawker means ये जो सूरत और जगह जगह से साड़ियां ला करके घूम करके जो बेचते हैं, रिक्शा में लोड करके या साइकिल में लोड करके जो डोर टू डोर घूम कर, like that.
Okay.
So therefore, my lord, 15,000 rupees, my income, and a family of 6.
Family of 6.
It cannot be possible for family of 6, only on 7,000 they will survive.
What was the father? Your father depended upon you. Is there any evidence?
No evidence, my lord. But it has come that they are all living together.
And date of accident is?
Date of accident is, my lord, that is 24/4/2012.
No recovery?
No recovery.
Yes, Mr. Roy. SG Roy, you are appearing? Or who is appearing in this case?
So I am appearing on behalf of the respondent number 3, insurance company.
Your Lordship, I am appearing for respondent number 1 and 2.
So ultimately, respondent number 3 has to pay the amount.
Lordship.
So how much? Tell me. Any chance of settlement, Mr. Lal?
Yes,
Mr. Roy?
Mr. Roy is ready.
At the best, since there is no proof of income, 7,000 is all right. And only loss of state and future prospect can be added. But the interest is 9%, it's more than, should be 7%.
But that is from the date of award, not from the date of making application.
That is from the date of award. No, just tell me one thing.
We have deposited 11,88,097.
He has received that?
Yes, ma'am.
What was the deduction? What was the deduction?
Yes, my lord. 1/4. Deduction is cut 1/4.
That is all right.
Multiplier?
Multiplier is 18.
So what was the age of the deceased?
27.
It should be 17. Then tell me if you both are interested in settlement. I'll refer the matter to the Lok Adalat, and I think it can be settled.
It can be settled, my lord.
How much are you expecting?
It depends how much my lord is considering regarding income, my lord.
I am no one. If you want to settle
Because
your
7,000 was my income.
Mr. Roy.
What has 7,000?
It is Mr. Roy. It is you and Mr. Roy.
Yes, my lord.
Yes.
Let it be for next Monday, my lord. Then in between, we both will discuss and settle the amount.
$11 lakhs. All right.
अगर 11 लाख आप बोल रहे हैं तो हम एक्सेप्ट कर लेते हैं।
नहीं 11 लाख तो पे कर ही दिया आपको।
वो तो कर दिया। That is right.
50,000 at the best can be 50,000. 50,000 can be at the best handed.
Yes. $11 lakhs have been paid.
My lord.
What is the total amount paid? 1149.
1149 is the principal amount and plus some interest.
Something between 5 to 6 lakhs more. Mr. Lal?
My lord. And
something between 5 to 6 lakhs more.
I will check, my lord, and let it be fixed the day after tomorrow or Monday, my lord. So
Monday,
that
Monday under the heading for orders.
my lord.
On Monday.
Serial number 27, MN number 572 of 16, Ms. Sunita Ojha, for the appellant, Mr. Yogesh Prasad, for the respondent.
I am appealing on the behalf of the appellant, my lord. This appeal is filed award against the MSCT Ranchi. That is the main grounds for filing appeal. Deceased was the 60 years old and earning was not proved by below court. And personal expenses which is considered by the lower court 1/4. That is not proper. Third ground is the allowed interest 9% per annum from the date of the filing. That is not proper. The driver is not made party of the Maruti van.
What was the age of the deceased?
60 years.
You appear for the claimants. LCR is here. Call for the lower court records as the quantum of compensation is under challenge.
I am appearing for the respondent number 5, honor of the vehicle, my lords.
Where are the claimants are not appearing?
Perhaps, my lords, they are not appearing.
Full stop. The claimants are not appearing. Full stop. I direct the Jalsa to establish contact with the claimants and ascertain whether they need any legal assistance or not. Full stop. If they need any legal assistance, Jalsa will provide the same to them. Stop. This case after 4 weeks. Next.
Serial number 28, MN number 576 of 16, Mr. Vijay Kumar Sharma, Mr. Abhi Kumar for the appellant, Mr. Manish Kumar for the respondent.
May Lordship. An instant memo of appeal has been filed by the claimant Lordship against the order of the learned tribunal Lordship. Learned tribunal has dismissed the case of the appellant Lordship on the ground Lordship. Appellant has proved the due to own negligence, accident by occurred Lordship.
Who is the deceased?
Injury case, Your Lordship, not the.
Who is the injured? Who is the injured?
Injury, Your Lordship, driver of the vehicle, Your Lordship, Pasupati Singh, Your Lordship. Urgent Clement, Your Lordship. In this case, Your Lordship, LCR is required, Your Lordship. LCR has not called for, Your Lordship.
Where is, let me see, where is the finding that the driver was, what was the
Lordship.
Issue number 3, my lord, paragraph 14. Page number 11, running page 11.
Yes.
To prove his issue, claimant has filed exhibit 4 showing a cumulative bill of such and such issued.
Where is the finding that the defects?
No, it has come in the, yes, it has come, my lord.
No.
Para 18.
How the accident occurred?
My lords, he himself was driving the truck. He claims that bus, my lords, he claims that there was some technical problem in the bus which led to the breakdown. There is finding of fact that the accident was due to his own negligence. No other vehicle was involved. And that has been paragraph 15 onwards. If my lord,
Call for the lower court records. Call for the lower court records. Yes, next.
Serial number 29, MN number 654 of 16. Mr. Vijay Kumar Sharma, Mr. Amit Kumar Bhattacharya, Mr. Manish Kumar, Mr. Ramesh Kumar, Mr. DC Gold, for the respondents.
My lord.
May please, Lordship. Instant memo of appeal has been filed by the claimant's appellant for enhancement of the compensation amount, Your Lordship. Learned tribunal has awarded that amount, Your Lordship, 4,20,000 with 7.5%, Your Lordship. And due to contribute negligence case, Your Lordship, so they allow the 2,10,000 plus 7.5% interest from the date of the filing, Your Lordship.
What is your contribution towards the accidents?
Lordship, it has come in the finding, Your Lordship.
So you are driving a motorcycle. You are driving the license.
No, Your Lordship. This is by the pillion rider, Your Lordship. And vehicle was drive by the, you know, one of the Mukesh Kumar, Your Lordship.
The deceased.
And no, Your Lordship. It has come in the finding also, Lordship, and the evidence of the AW2, Your Lordship, and the eyewitness of the case, Your Lordship.
On what ground? What is the finding about the contributory negligence? Which issue? Where is the issue of contributory negligence?
Issue number 3, Your Lordship.
3. Read issue number 3.
Whether the opponent, Lordship. But Your Lordship, as per the evidence, issue number decided 1, 2, 3, Your Lordship, and both the paragraph 7, Your Lordship. It has come in the finding, Your Lordship, of the page 10, Your Lordship, and the page 11, Your Lordship, of the impugned judgment, Your Lordship.
Any eyewitness?
It Witness, Your Lordship, the drive, Mukesh Kumar, Your Lordship, AW2, Your Lordship, CW2, Your Lordship, CW2, Your Lordship, CW2, Your Lordship. It has come in the
Okay.
Lordship.
He was the driver of the motorcycle.
He was the driver of the motorcycle, Lordship.
Yes, where is the LCR? Yes, the insurance company.
My lord, subsequently paragraphs, the court view has discussed the person who was driving the vehicle had not received any injury, not even a scratch.
Maybe.
And thereafter,
Maybe.
my lord,
Maybe.
my lord, certainly,
But
my lord.
there is evidence that AW number 3 was driving the motorcycle.
My lord.
There is no proof that it was deceased who was driving the motorcycle.
My lord.
So, that is the question of contributory negligence.
Yes, my lord. That is discussed in detail from running page 9, 10.
Yes.
9, 10, and ultimately the finding has been given in para 11. Some long judgment, long paragraphs. Record reveals that the claimants have not produced in driving license, RC book, insurance I'm reading page 9 of the judgment. The FIR itself reveals that the informant Mukesh Kumar has not mentioned in the FIR that he was riding the motorcycle at the time of occurrence. Rather, he has stated that he was coming along with his maternal uncle Suresh Kumar by his motorcycle. From perusal of record, it appears that CW2, who informed the police about the accident and on whose FIR was lodged against the unknown tractor, driver stated that he was driving the bike at the time of accident. CW3 stated that at the time of occurrence, Mukesh Kumar was riding the bike, but claimant number 1, wife of the deceased, CW1 herself, admitted that at the time of accident, her husband was riding the bike of his Bhagna, Mukesh Kumar. It appears that how a claimant herself would speak false against her case. CW3, the own brother of the deceased, admitted that occurrence took place in the center of the road and both motorcycle and the tractor collided on head. Head is there.
You just come to the page 15. Last paragraph. Last 3 lines. It further reveals that the occurrence took place in the center of the road and the driver of the motorcycle died on spot. And it is difficult to conceive that the driver of the motorcycle would have got simple injuries, whereas the pillion driver died. Even both the motorcycle and the tractor collided head on.
My lord.
That means the court is presuming that it is impossible to believe that the driver of the motorcycle will not be injured or will sustain only simple injuries, and the pillion rider will drive in a case of head-on collision.
Of course, regarding the this part is this is not finding.
This perception is absolutely incorrect, Mr. Ghosh.
My lord. Then in the next paragraph, perusal of the exhibit C reveals that alleged motorcycle JH number such and belongs to Yugal Thuri, village such and such, Chatra, from dated such and it was transferred in the name of Akhilesh Mistri, a Shuchit Mistri of village such and such, and policy has been brought on record for the sake of argument if it is assumed to be correct that on the date of occurrence, CW Mukesh Kumar was riding the bike and the deceased himself was also traveling as pillion rider without verifying the RCDL insurance policy of the motorcycle. Moreover, Mukesh Kumar has not been implicated party. It thus appears that the claimants have waived right against the driver of the motorcycle number such and such, as deceased himself was also responsible for riding the motorcycle without any license and insurance policy. It thus appears that at the time of occurrence, the deceased himself was driving the motorcycle.
On what basis this finding has been arrived at? Just because the deceased died in a head-on collision?
Yes.
This is
Yes,
this is not a finding, Mr. This is not a correct finding assessment also.
My lord, my lord. Then next page, next page, my lord.
Mr. Ghosh, I am telling you, I have
Yes.
come across a head-on collision. I have seen one where a motorcycle dashed against a running bus. The driver of the motorcycle escaped unhurt. The pillion rider got crushed.
Certainly. My lord, my lord.
I have seen it. I have seen that accident. So this finding on this presumption is absolutely false. It's incorrect.
The exact finding has been recorded in the next page, my lord. Of course, the same finding, the same language. Therefore, in my considered view, the claimants have established that the dependent was caused due to such and such part of the tractor driver of the an offending vehicle and the tractor bearing number such and such was insured with opposite party number 3. This fact also cannot be denied that the deceased himself was also responsible for riding the motorcycle.
These subsequent findings or subsequent conclusion is on the presumption that the deceased was dead. Now, if it is held that there is nothing on record to suggest that the deceased was driving, then all this presumption goes, all this conclusion goes.
Yes, my lord.
Then, and the earlier this exhibit C, that is in respect of the motorcycle. So then what happens? Then at best it is a case of composite negligence.
My lord.
Then the claim is against the owner of the tractor.
My lord, kindly come to para 9 because there is a finding regarding the interest liability.
Yes.
Para 9 of the law.
Yes.
On care, running page 19.
Yes.
On careful perusal of record, it appears that the tractor was insured with opposite party number 3, New India, through valid policy, but the driver of the tractor had no valid driving license to drive the tractor at the time of accident. The owners have not produced any evidence regarding necessary precautions taken by them before allowing a person not holding a DL and authorized him to drive a tractor on road. The owner cannot play game with the life of the people.
Right recovery has not been given.
The finding is that hence the owners have committed willful breach of terms and condition of the insurance policy. Therefore, owners and driver of the tractor 1 and 2 here and 3 are liable to pay compensation. If this finding is against the 1 and 2, there is a breach.
1, 2, and 3. 1, 2, and 3. That means you also. You also.
I have not committed any breach.
No, so it says that 1, 2, and 3. Therefore, the owner's driver of the tractor, that is OP number 1 and 2 and 3, are liable to pay compensation up to the extent of their liability.
My lord.
So if there is, this is held that there is a violation of the policy, but fact remains that no right to recovery was given to you, and you have not challenged the same also.
That has not been challenged. Only that portion I am pointing out.
So now it's 1:30, second half is a different bench. Heard in part, further tomorrow.
Complete हो गया इसमें और तो कुछ है नहीं
Further
enough
tomorrow.
for enhancement है
have to go through the record also.
My lord.